Hello and welcome back to the Self-Represented Litigant Society's legal terms that begin with the letter H. I want to remind you that we are going to be publishing a PDF document of all of our legal terms found in this video series. That's going to be published on our website in the members section, so you can become a free website member of our website, irepmyself.com, and that will get you free access. All you need to do is put in your email address and create a password, and you will have free access. Habeas corpus is sometimes referred to as the Great Writ. It is Latin for "you have the body." It's basically a procedure for obtaining a judicial determination of the legality of an individual's retention in custody, or, their possession in a jail cell. I want you to take a look at Section 10C of the Canadian Charter of Rights and Freedoms that specifically deals with this specific term. Now, a writ is an order that has been passed down from the ages, and essentially it's a procedure, or sometimes it's not even a formal procedure. It's something where where the Crown has to essentially show, in Canada, the Crown has to essentially show that you have been detained properly and that the charge is properly in the form that it's supposed to be. And that's the wording of the actual charge. Now, if it or the circumstances that the Crown alleges or the police allege do not line up with what constitutes an offense, essentially that person will be set free. Doesn't happen very often, but it is the Great Writ, and that is something you should know. A hearing is a generic label to describe a proceeding. There are several types of hearings. I'm going to go over just a few of them in a little bit of detail. A default hearing in family law cases is a hearing in which a payor, or a child support payor, is required to come to court to explain why payment has not been made as required by a support order. In criminal law cases, when the accused has broken the terms of their bail, the court sets out a process for the court to order default estrepment of bail. This is essentially a hearing where the person that has put up money or the person that is charged with the offense will essentially lose money or have the money that they pledged to not break their conditions or their recognizance taken away. This estrepment hearing is essentially going to go after approximately 10% of the money that was pledged to the court. And the person, the surety who put up the money, can also be involved in an estrepment process or an estrepment hearing. And it can also be something where the person who actually is alleged to have, you have to be found guilty first of the breach of the condition before the estrepment can happen. And then it can be that the person who essentially breached the condition, they can essentially go through the estrepment process. But, there are also other types of court fees that can be dinged along the way, such as a victim surcharge fee. And that's something that can be added on pretty much to every guilty finding. A fitness hearing is a criminal code procedure to see if an accused is mentally fit to stand trial. A temporary care and custody hearing in child protection cases is a hearing that may be held to determine who will have the care and custody of a child who has been apprehended by the Children's Aid Society or another protective agency, until a final order has been issued in the case. Hearsay evidence is written or oral statements made out of court and spoken by another person testifying or in court, or by giving a sworn statement, for instance in an affidavit, generally inadmissible or not usable unless the type of statement made falls into an allowable exception. Now, there are a lot of allowable exceptions, and there are a lot of ways that you can have hearsay excluded. So, this deserves more attention. Please take a look at our video currently on our channel as to hearsay, and that is just a start of where we can start the discussion about hearsay. An heir are those who are designated by statute or by written, formalized law or legislation to inherit an estate or a portion of an estate of an ancestor who dies without a will. HMQ, or Her Majesty the Queen, is the crown in right of the provinces and in right of Canada. Essentially, it's the state, and it has the power to bring an action against someone, and in the same right can be sued. In criminal matters on paper, HMQ is referred to as Regina, which is the Latin word for queen, and is shortened most of the time to the letter R. So R versus whatever. That's how you can usually signify that's how you can usually identify a criminal case, obviously. A holding company is a corporation that owns or controls other corporations. Homicide are a category of criminal charges for killing someone, including first-degree and second-degree murder, manslaughter, and infanticide. A hostile witness is a witness which may also be referred to in some circumstances as an adverse witness. You're going to want to take a look at these references in the Canada Evidence Act or the Evidence Act in your specific province. This is a person who has exhibited such a hostile animus or ill feeling towards the party calling them to reveal their desire to not tell the truth. And if you're the person calling a witness and they are deemed to be a hostile witness, typically you cannot cross-examine your own witness. And if you have a hostile witness, if you have a witness that you call declared a hostile witness, then it could be that you're allowed to cross-examine them on certain issues or all the questions. A hybrid offense, which is heard more commonly here in Canada, is a criminal offense which can proceed as an indictable offense, or as Americans might refer to as a felony offense, or as a summary offense, or summarily, or this is a lower, a lesser serious charge, referred to sometimes as a misdemeanor charge. So the charge can proceed as either one of those, as an indictable offense or a summary offense, and it's up to the Crown to decide, typically at an early stage, how the Crown is going to proceed with the charge. So they can choose to either proceed as an indictable offense or as a summary offense. And I believe the Crown can change that up until trial. But typically, for some procedure, the Crown needs to be able to allow for the accused to access some procedural steps. For instance, in an indictable offense, you're allowed to have a preliminary hearing where you're not in a summary offense. So the Crown has to give the accused person an opportunity to be able to book a preliminary hearing if they're going to proceed indictably. And with the same thought in mind, there's a certain point, I believe, where there is I don't know if it's trial or not. That's a question that I would have to research. But I believe there's an actual, cutoff point as far as procedure goes as to when the Crown has to make a choice. But I believe ultimately it's at trial. Thank you again for watching the Self-Represented Litigant Society's Common Legal Terms series. Check out our website and become a free website member to access a free copy of a PDF of every single legal term we've discussed in this series once they're available. We are shooting for the end of April 2016 to have that PDF copy ready for download. And a free website membership from irepmyself.com. It only takes a website, or it only takes an email address and a password to have access in nearly seconds to lots of great free information like this video and other great referrals and legal information produced by a number of different sources, not just us. Anyway, thanks for watching and stay tuned for the next video in this series.